Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the offices of Rajiv Khanna PC. This is our bi-weekly, every other Thursday conference call for the community. We'll answer first the questions that have been posted. Within those, the questions that I have marked as frequently asked questions first. Once we are done with the posted questions and the follow-ups on the posted questions, if time remains, we will do new questions. Okay, I'm starting a few seconds early. Let me just make sure I've got everything lined up. Oh yeah, I'm following my Twitter feed. If there is any problem in the call, you can just go ahead and tweet it out to me. Let's begin. It's now 12:30, so we can begin. Let me start the frequently asked questions first. We have actually an unusual number of frequently asked questions today. One is, I have a pending H4, but my F1 is approved. So this kind of situation comes up when you have more than one status applications pending. So what to do when one is approved and the other one is still pending? What is the right thing to do? So let's take an example of this where F1 is approved, but H4 extension is pending. Okay, F1 is approved, H4 extension is pending. Now, since you want to stay on F1 status, you should immediately write to USCIS, put it in writing, and make sure you send it through something like a FedEx or a UPS or a certified overnight mail so you can prove the delivery of the letter. Okay, that way, once you have sent the letter of withdrawal out, there is very good argument that any subsequent approval of H4 does not hurt your F1. Since you have already indicated an unambiguous intention and made a request to the USCIS to revoke or withdraw an application that's currently pending but you don't want it to be acted upon. What is the risk here? And the risk here is, as Krishna properly pointed out, the risk here is I've got my F1 already approved. I don't want the H4 to be acted upon because there is something called the last action rule, which is really not a rule but merely a matter of common sense as applied by USCIS often to these situations, that whatever status is approved last would be your status. So you have F1 and H4 going at the same time. You've got your F1 approved. If the H4 gets approved, then you're back on H4. Okay, so at least that is the conventional wisdom, and there is some question about whether or not that is correct. But nevertheless, smart thing to do is, I repeat it, if you already gotten the approval that you want, go ahead and revoke in writing what you don't want. Okay. Does anybody have any question on this issue, withdrawing one pending application when another is approved? If you do, press *5 on your phone. Okay, I'm gonna go on to, oh, there is one. All right, let's do that. Washington, go ahead, Washington.
Rajiv, this is Krishna. I mean, I was the one who posted this question.
Yes, sir.
So actually, we have gone to InfoPass in our local USA's InfoPass, and they confirmed this H4 is already withdrawn. But when I looked at the USA's website in my cases, so it is pending with the USA. So that's why I'm little worried about this H4 extension.
No, don't worry about that, because the USCIS website may not be as updated as the InfoPass is. Think about the USCIS website as a graphical user interface which is not connected in real time to their backend database. Whereas it is my understanding that the InfoPass uses the same database nationally. So InfoPass is looking at live data from your petition.
Okay. So as I have already sent the withdrawal letter, so if at all, I mean, by mistake, worst case, if H4 is withdrawn, then it's no need to hurt about that. Right?
I am not worried. I am not worried. You have done everything that you were legally required to do.
Okay, sure.
All right.
Thank
Good luck, Krishna. Okay, let's go on to the next frequently asked question. I want to do the frequently asked questions first. Also very often asked, writ of mandamus. Should I file a writ of mandamus if my case is pending too long? Whatever that case is, I-140, 485, H1, L1, naturalization. Guys, you need to understand what mandamus is. Mandamus, okay? A writ is simply an order of the court or a formal order. Mandamus is to ask the government to do something which it is legally obliged to do. It is important to understand what the court can and cannot do. First of all, the court has to decide whether your case has taken too long, unreasonably long, to the extent where the delay itself becomes unreasonable. It's a very difficult thing to prove, depends upon the court. Okay. There is a ruling. I remember litigating this issue very vigorously in Washington, D.C. and one of the cases that was against us was a case from Board of Indian Appeals. I think that's what they're called, BIA. Not to be confused with Board of Immigration Appeals, but Board of Indian Appeals. There was usually if a group of people want to be declared an Indian tribe, because if you're an Indian tribe, one of the things you can do is have unique rights within your own area, such as opening a casino. Okay, so they had a determination pending for over 10 years, and court said that is not unreasonable. So first hurdle is to actually be able to prove. Of course, before that there is the hurdle of legal fees. It can be quite expensive to litigate an issue. Second hurdle is proving that the delays are unreasonable. Unreasonable according to what? Government processing times are merely guesses. They don't give us a right. Okay. The third thing, which is also important, court cannot ask the government to decide the 485 in your favor. They can only make government act, whether the action is yes, no, or an RFE. And this brings me to my final point, which is something I find very odd. I would never have believed it to be possible until I saw it happen myself. Government can behave like a spoilt child, like a petulant child. Because they have lost the case, they can send you a 30-page RFE requesting information that you would not believe could even be asked. So, because the court cannot tell the government to decide the case in your favor, they can only order the case to be decided yes or no. You could end up creating more issues. And the Freedom of Information Act request usually doesn't help in these cases much. Okay, so keeping in view all these things, personally, my approach is very simple. I tell people, are you at the point where you are just so sick and tired, you either want a yes so you can get your green card and stay in this country or get naturalization, whatever the benefit is, or get a no and just leave, one way or the other. Once you come to that point, that's when I want to litigate. Before that, again, it also depends upon the circuit. You know that in USA, there are different judicial circuits on the federal level. So some circuits are more open to certain issues, some circuits are not open. So we have to look at the law of the circuit also. Okay. So anybody has a question about writ of mandamus, press *5. Anybody has a question on writ of mandamus that we talked about, press *5. *5. Okay. Let's go on to the next frequently asked. Oh, there is one. Sorry. California, go ahead, California.
Yeah, California.
Yes, ma'am.
Yeah, so I have also posted my question there that we are.
Oh, ma'am, I'm sorry. Hang on one second. This is only a follow-up question of writ of mandamus. No new questions right now. Okay.
Okay.
That'll be the end.
The thing is, according to you, you suggest that we should file mandamus or consider that option when everything is exhausted, like dealing with lot of inquiry.
Right. What I
That should be
believe
the
is,
last option.
I'm sorry, I thought you were asking me a new question. What I believe is, a writ of mandamus should be filed as a last resort, except where the law of your circuit or the process in your circuit is quite favorable to you. If you are in California or Washington State, typically the circuit is quite benevolent. They're quite kind for immigration purposes. So these are probably the best circuits. This also the Seventh Circuit, which is the Midwest, Illinois, etc. These are good circuits. DC can be inhospitable. So you have to look at the law of the circuit also. But overall, my suggestion is do it only when you're sick and tired and you want a decision. You don't care what the decision is.
Okay, thank
All
you.
right. You're welcome. Good luck. Okay. Let's go on to the next frequently asked question. Can I buy an investment property while on H1 and rent it out in my own name without creating a corporation? This is another interesting question. Can I do any business on H1? Can I do this kind of business? Can I start my own IT company? Somebody had asked this question further down. And for that, let me begin with the bottom line. Some things are not clear, some things are clear. First of all, in my view, passive investment, where you are just putting in money and have no control over what happens to the investment, it's okay to do that on H1. So if you buy stock in IBM, that's okay because you don't get to manage or run IBM just because you bought $200 worth of stock. Okay. So passive investments where you don't actually control the investment or the business activity, they are okay for H1. But when you buy and rent out a house, I think that would be objectionable. I think that could be considered to be a violation of your status. What if you invested money in a small company, let's say a 2-person company, where you own 100% stock, but you're not managing, somebody else is managing? I think that would be okay. That is closer to being okay. Can you start your own IT company? Well, if you did it in a partnership and if you were a passive investor, sure. If you want to also work for that company, you would have to have a true employer-employee relationship with the company. That means somebody should be able to fire you and then you should file an H1, a concurrent H1 for your own company. So the decision tree is my investment active or passive? If it is passive, no problem. I can invest even when I'm on H1. If it is active, I would have to do an H1B for my own company and make sure I have an employer-employee relationship. I'm finding that government is very much more understanding or flexible when it comes to medical practices, dental practices, where you own your own company, but you have somebody who can fire you, whether it's a board of directors or it is you're not the president, somebody else is the president, even though you own the company in total or partially or majority, you could still be fired. As long as that is there, having an H1 through your own company is possible. Okay. Anybody has any questions on this issue? Buying and renting a house or investing while you're in H1, press *5. Anybody has any question on this issue? Press *5 on your phone. Okay. Let me go on to the next question. Also a commonly asked question, frequently asked question. Do I lose my priority date if my I-140 is revoked? The answer is yes, unless you are protected by AC-21. If you are protected by AC-21, I don't think you lose your priority date, and I don't think government has ever made that claim. When do you get protected by AC-21? When your I-140 is approved and 485 has been pending 180 days. Okay. So if before that, there is a history of this entire thought process. The current thought process of the government is that you will lose your priority date if I-140 is revoked for any reason, even if it is for no reason by an employer, you would lose your priority date unless you're protected by AC 21. Before that, government had for a couple of years maintained that you will maintain your priority date unless USCIS revokes a case for fraud or misrepresentation. Before that, a couple of years before that, USCIS had the same thinking that they have today. If the I-140 is revoked, you lose your priority date. I have looked at this issue, and legally, I think USCIS is correct that if the I-140 is revoked for any reason, you lose your priority date. Okay. So I'm looking at the questions posted by Rahulji, and I have answered pretty much all the questions you had posted, but there's one question. If I go from employer A to employer B, and B files the PERM before the A is revoked, I-140 is revoked, does that make a difference? No. What if, and this has come up, I did a consultation I think a week ago on this, somebody went a step further. Their I-140 with old employer was approved. They changed employers, did a PERM, got another I-140 approved with the priority date of the old case in the new I-140. And even that does not protect the priority date. Just because it has been stamped on your new I-140 does not mean it is written in stone. Government discovers the error or discovers that the old I-140 is revoked, they will go back and take away your priority date. The only way your priority date is protected under the current scheme of regulations is if you are protected by AC 21. Anybody has any questions on the issue of revocation of I-140 and loss of priority date, press *5 on your phone, folks. *5. *5. Any question related to revocation? Okay. Let's go on to the next frequently asked question. This is a long one, and this is probably going to take me between 5 and 15 minutes to go over all the various permutation combinations. What happens if and when I get laid off on H-1B? Problem number one, if you get laid off on H-1B, there is no grace period. You get laid off today, tomorrow you are out of status. Okay. So let me take the questions that have been posted by InfoRanjan and see if they cover the entire area of this discussion. I think it does. First question. So I've been laid off by my current employer with severance paycheck coming at regular pay intervals until mid-January. Finding a new employment is taking time. So my H1 is valid till 2017 December. So here are the questions. How long do I have before I become unauthorized to stay? Not even 1 day. Okay. However, when you are getting paid, can you not make the argument that since you are getting paid, you are still maintaining status? That's a slightly unpredictable argument. It can cut both ways. Yesterday I did a consultation with somebody. I did not know that such a thing existed. They were on something called garden leave. Garden leave is very common in the financial industry, where the employer lets you resign, or if they lay you off, they'll pay you for a couple of months, but they don't want you to join another employer. And the idea is that you shouldn't be able to take their information, which is current, and apply it to a competitor. So I think in that case, those paychecks are strongly set to keep you in status because it's full salary and they are maintaining control over you. They're not letting you do what you please. And that's the assumption. Okay. However, severance pay, government has at one point said that they don't consider severance pay to be maintenance of status, because severance pay seems to be a part of an arrangement where this is not salary. You are basically just getting paid sort of a bonus to part company. And I have my doubts about that. I do not believe that to be a very good legal opinion from the government. I feel as long as it is my salary amount is getting paid, my deductions are being made, it is salary. It does not matter whether I have a job or not. So you can certainly argue that. Severance pay, doubtful. something like garden leave or regular pay coming out your way, probably okay to maintain status. My I-94 is good till October 2016. Does this mean anything? Not really. You have a further down, I think you have a question about unlawful presence. Guys, understand the difference between out of status and unlawful presence. These are two different concepts. If you are on H1 and you get laid off, you are out of status the next day. But you are not unlawfully present until your I-140 is revoked. I'm sorry, until your H1 is revoked or until your I-94 expires. Okay, so revocation probably starts the clock ticking on the unlawful presence, but there's some doubt there also. For sure, unlawful presence begins when I-94 expires. So unlawful presence and out of status are two different things. You are out of status the following day, but you may not be unlawfully present until your I-94 expires or revocation of the H1 occurs. Consequences of being out of status and unlawful presence are quite different. If you're out of status, that is no bar from getting another H1B visa, another H4, L1, L2, maybe a problem for F1 or B1 visas that have a rather weak basis, but for H1, H4, L1, L2 type visas or even O1 or even E3, this is not a problem. On the other hand, if you are unlawfully present for 180 days, you are barred from green card or work visas for 3 years, 10 years if you are unlawfully present for 1 year. So you can't come back, okay, without a waiver. And waivers are very limited, very restricted circumstances. Third question, before I transition into a new H1, can I travel outside and into the country? No, because you don't have a job. If you use the same visa to come back in, that could be fraud. Can I use my severance pay stubs as pay stubs for next H1B? The answer is yes, why not? Government has never made a formal announcement that they will not accept severance as indicative of violation of status. So definitely use them. I'm hesitating to inform my next employer about my termination. This may impact my hiring. Is it unethical? Well, you know, that's between you and your new employer. Immigration law does not require you to inform your new employer about termination at the old employer. How long does the USCIS take to update a revoked H-1B petition? It can be many months, but the revocation should be retroactive. So if your employer sent a revocation request which reached USCIS today, even if they act on it 3 months down the line, they will backdate it to today. Okay, and sometimes it's so bad that I've seen some employers do that, and I find that very objectionable. They will send a request in today and ask for revocation effective 3 months back. And USCIS, without looking at the date on which the request was made, give the revocation going back 3 months even before the request was made. That's bad, very bad. So you should fight something like that. But revocation is effective on the date the revocation request is received. Next question. If my new employer files for H-1B before the update, before the revocation, but pay stubs older than 30 days, do I have to leave the country? It's up to USCIS. They might allow you status if your facts of your case are such that they require some sympathetic consideration. But normally, if you are out of status for even 1 day, government is well within its right to refuse to issue you status within the country. In these cases, I always advise people, please file premium processing so you know rather quickly where you stand. Should I change to B2 status? Now this is something I want to devote a couple of minutes to. B2 application to maintain status is acceptable, sometimes objectionable by the government. You can try, you can tell them, make some things clear. I think I have a couple of blog entries on this subject. Make it clear to the government that you were laid off unexpectedly, you have enough money to support yourself, you will not work without authorization, and that as soon as you find another employment, you will immediately apply for an H1. When all these things are said and done, I think you can make a case for a B2. Sometimes government has come back and said, oh, B2 is not a catch-all phrase, a catch-all visa, we cannot give you a B2. But you know, as long as you get it filed before your current H1 expires, you know, at least you have a colorable right to stay in the US. You can argue that you are in what is called authorized period of stay. But the problem is this. This is something you need to be aware of. Let's say your status has expired, but you have filed for B2, it is pending. Now you found a job. Remember, an H1 transfer within USA will be approved only, most cases, if the pending B2 has been approved in your favor by the time USCIS decides the H1 transfer. If the case is still pending, they will not give you status within USA, they'll ask you to go get visa stamping. That's not a problem. You can do that. But be mindful of that. If the B2 is still pending or if the B2 is denied, you will have to leave USA. The only time you get H1B within USA is if by the time they decide your second H1, your B2 is already approved in your favor. You will be cap exempt. That is, cap is not a problem because cap just says if you have been approved anytime within the last 6 years, you are not subject to the quota. Okay, so there are certain ornamentations on this issue, but overall this is the rule. So remember that if you have been approved, in your case, that should not be an issue at all. In some other cases, it might be. Can the old employer continue to pay severance checks while I'm on B2? Why not? Because on the one hand, we are arguing that that's keeping you in status. On the other, government could take the position that means you are violating status. And I would say no, because that is payment for work already done. They are giving me severance not because I am working for them. It's because I already worked for them, and this is either a payment for work already done or part of the arrangement when I was working. So there's no new work. In order for employment to be unauthorized, there must be a payment or remuneration as well as work. If there is payment without work or work without payment, I think there's good argument that that's not unauthorized employment. 10th question. What happens if my new employer applies for H1B transfer after the revocation? Don't worry about it, already answered. In your experience, what gap in unemployment is generally ignored? There is no consistency. I have seen them ignore not even 1 day. They'll come back and say, no, you were out of status for 1 day. In some situations, they have done even 2 or 3 months. Unusual, most of the times they are not tolerant of this issue at all. And Amit says, what words of wisdom do I have? I think B2 is a good idea as long as you understand the implications of a B2. So yes, I think B2 is a good idea overall. Okay. Anybody who has a question on being laid off while on H1, just the area that I have discussed, press *5. Any questions on getting laid off while on H1B, press *5. Let me check my tweets also in the meantime. It's all going good. Okay. So Amit has also some series of other questions. I'll address them as best as I can. We've spent a lot of time on this, but you asked about owning your own company on H1B. That was my second or third frequently asked question that I discussed today. So go back and listen to that. You have a STEM degree. Can I sponsor myself on EB2? Very unlikely. Very unlikely. And LCA and PERM are two different things. Don't confuse the two. You have to go through PERM. Employer will have to do the green card process. Exceptional remuneration is probably 3 or 4 times the amount people get paid. And EB1, exceptional remuneration is not the only criterion, unless it is so exceptional. If your contemporaries are making 100,000 and you're making 700,000-800,000, maybe we can make a case for it. But these are not, extraordinary ability alien categories are not that easy to approach. Okay, so I'm going to go on to, okay, those are all my frequently asked questions. Now I'm going to go into the regular questions. So one is from EEF, who came to USA on a TN dependent visa, which is TD, expiration date December 2015. Then you got a job and got TN in October 2013, expiration October 2016 on the TN. Officer said keep the TD visa I-94 also. And then you got laid off after 1 month. That means you have been laid off since November 2013, if I'm understanding this correctly. I personally think you need to go out and come back on your TD visa, which is what you will have to do, which is basically like an application for a new TD visa. Or you can apply, you won't get a change of status because you've been out of status for so long. My only concern is, do you have any unlawful presence issues? An unlawful presence issue would occur if you had no I-94 that covered you for the time that you are here. So if your cases have not been revoked and your I-94s are good, either one TD or TN, I think you should be okay. Okay. So if I were you, I would just double check with the employer who did your TN, make sure they did not revoke your TN visa. If they did not revoke it, you should go outside, get your TD done and come back. That would be the smart thing to do. Okay. Any questions on this TD, TN, *5? Okay. Next was the frequently asked question. We have dealt with that. Next is from Fever ITXYZ. I-140 approved, priority date 2012, moved to company B, PERM approved, I-140 pending 302 days from company B. A, which was the first company, got acquired by C. Don't know what type of acquisition. Company A's website still exists, that doesn't mean anything. Wife's H480 got approved using company A's I-140. A numbers are matching. That also doesn't mean anything. A number matching does not mean anything. Can I assume that my I-140 with company A is intact? I don't know. Unless company A or company C actually revoked, you could certainly claim the priority date to be still intact. So normally lawyers don't have to remind companies to revoke anything, even H1 or I-140s. The type of acquisition that is considered to be okay for carrying the green card forward to the acquiring company is called successor in interest or successorship in interest, which basically means the new company took over either the whole, all the assets of the old company, or a discrete divisible unit of the company. It's kind of complicated to describe it in a few lines. You should talk with the lawyers. So why is my I-140 pending for over 300 days? That usually bothers me because that typically means that there is some investigation going on, and usually I-140s could be about the employer. So are there other cases also taking that long? And if they are not, then it could be something to do with your background. I would just stay with the congressman and see if the congressman can make further inquiries for me. Okay. Folks, any questions on these issues that I just discussed? Press *5. Okay. There is one. California, go ahead, please. California.
Hi, Rajiv. This is Blvd here.
Yes, sir.
So, a couple couple of questions. One is the EIN. If the EIN is still the same, does it mean that it's not completely acquired?
It could. I'm not much of a tax expert, but if they are using the same identification number, that tells me that chances are that you are safe.
Okay.
Okay.
And the other question is, since the export EAD was approved using the previous employer's I-140, does it not mean that the I-140 is still valid? I mean, it has not been revoked based on my
Yes.
conversation with
Yes.
company.
Yes. It is a very strong indication that that I-140 has not been revoked.
Okay. On the A number, having the same A numbers on the current H1 approval notice, does it have any significance?
See, let me explain to you what an A number is. A number is simply a file created for you by USCIS, which is the rough equivalent of a social security number on the immigration side. So by itself, it has no significance. Okay?
All right. And for understanding, starting if it is a successor in interest, who will be the best person for me? Would it be the company or the attorney?
The company,
interest or not?
it would probably be the company unless the attorney was involved in the acquisition. See, we are often involved in mergers, acquisitions, takeovers, stock transfers, because when you have larger companies doing these transactions, there are certain immigration angles. Just by planning things a little bit differently, we can save a company a couple of $1 million or even more, depending upon how we do things. So we are involved, we know what the transaction is. But many times if the lawyer is not involved, they would not know. So you can start with the lawyer. If they know, great, otherwise go to the employer who has taken over the old employer.
Okay. And the last question that I have is, if I receive an email from the company's team, the owner of company team saying that I would be happy to hire you, is that sufficient for successor interest, or there is not much paperwork?
I want you to do a consultation with your employer, with your lawyers. If you want us to answer that question, I would have to look at the company's tax returns, because I want to make sure that the company has the capacity to pay you wages even though you're not working for them. That's a very tricky issue. Okay, now somebody could say, well, the I-140 is already approved, why is the ability to pay wages an issue? And the answer is, technically, ability to pay wages must be maintained till you actually get the green card approval. So I have known USCIS to reopen I-140s and ask for proof of ability to pay wages. In fact, we are in the middle of a motion to reconsider on something like that. Okay.
Thanks, Rajiv.
You're
That's
welcome.
all the questions that I have.
You're welcome.
Really appreciate it.
You're welcome. Good luck. Okay. Next question is Begar, who says employer hires an employee. There's no other questions. Okay. Employers hire an employee on H-1B visa, file for green card for future employment. Several months later, employer terminates. Well, this is an interesting case actually. So the employer, a future employer, terminated the H-1, but the I-140 had been approved and the 484 was pending adjustment. Employer didn't do anything on the green card side and the green card got approved. Okay. He was not eligible for portability as it was approved in less than 180 days. What do I do with this? So, future employer, green card pending, H1 withdrawn, but green card not withdrawn, green card got approved before 180 days. I think you have a legal issue here. And I think the legal issue is, if you have gotten approval before 180 days of pendency, you may not be able to take shelter in AC-21's lap. I think you should very strongly request, this is the easiest practical solution, request the employer to hire you back on an indefinite basis. Permanent equals indefinite. It doesn't mean forever, with no end in sight. And that would take care of your problem. Otherwise, this could become an issue at the naturalization stage. I mean, nobody's going to question your green card now, but at the naturalization stage, it could become an issue. This is definitely a problem with the operating procedures in the law itself. Sometimes your case gets approved even before you had a chance or have the benefit of AC-21 portability. So now there are other arguments that can go against that as well. I would argue, if I were representing you, I would argue that this is not my fault. This is a problem in the procedures, and you cannot take away my green card once you approved it. Okay, not on these bases. When I have the intention to join the employer, and then that's another interesting point. I would put it in writing. I would say, my green card has been approved. Can you please offer me my job? There are cases on the books where if an employee reports for duty and the employer is unwilling or unable to give them a job, they maintain their green card. Let me check my tweets. Somebody just tweeted to me. I'm not sure if Mr. Avinash is on the phone. He's tweeted to me. Maybe I have time for new questions. We'll deal with them in a few minutes. So what were we talking about? Yeah, so this is an issue, and I think you should put it in writing. Tell the employer, I'm available to work. Can you please offer me the job? My green card has now been approved. Okay. There are two issues with that, which is, one issue is, what if they then send a notice to USCIS saying, please revoke his I-140? It could be problematic. Okay. So I think the best practical solution, my number one choice would be, get in touch with the employer, get hired back for an unlimited duration. But if in a week or 2 weeks or 3 months or 4 months you have to leave, or the employer asks you to leave, perfectly legal on all sides. Okay, but don't sign on with the preconceived intention to leave. Number one. Number two choice would be to put something in writing saying, please hire me back, I'm available. You have no obligation. I would put it in the email also. I'm told that under the law there is no obligation to hire me back, but if you could, that would complete my green card process. That way the employer doesn't feel threatened and they don't take any action against you. Something like that could be a good practical solution. And the third option is to do nothing, but that I just dislike. I think the first two options are good ones. Press *5 if you're on the phone. Press *5 if you're here. If you have any questions, press *5. Okay. We talked about writ of mandamus. Another interesting question from Ramki Shanamugam. My wife wants to know if she can work as a freelancer for companies outside USA while she's on H4 in USA. And the answer is, I didn't think so, but I have known many cases where this kind of an arrangement was approved without objection by the government. How did that come up? Somebody was entering the USA at the airport, they were asked these questions. And I've seen two cases like this. In fact, one of them just went from H4 to H1. They've just moved to Washington, D.C. area. I got an email from them yesterday. And there, the entire work was for companies outside USA. The companies had no connection with USA. No money was passing through USA. And government backed off and said, yes, that arrangement is okay on H4. I don't know if this is right or wrong. It seems wrong to me because I feel that work done on US soil should be censorable or capable of being objected to by the government of the United States. But it appears that government has at least upheld it in a couple of cases that I saw, as long as there was no revenue connection with USA. Okay. If you're on the phone, press *5. If you have a question, press *5 on this issue. Next question is about cross-chargeability in a birth certificate. Born in Iraq does not give me anything, but the consulate, Indian consulate in Baghdad says, here's my certificate of birth. Okay, there's a raised hand. I'll get to that in a minute. And is that going to be okay? So if you can demonstrate that that indeed is the local procedure, you should be okay. The fact is you are born in Iraq. Only question is, what evidence is acceptable. So my answer to that question is, as long as that is the usual what they do in Iraq, you should be okay. All right, I have a raised hand. Let me go to that. Oh, I know you. I have known you for many, many years. How are you?
I'm good. How are you?
Good. My God. Blast from the past. How the heck? What's happening with you? Why are you on the phone?
I had a question about, I have a pending, I think I just missed your answer.
Okay.
I have a 485 and it's been pending for a long, long time now. It's outside of the window already.
Okay. Here is my brief answer. The answer is pretty long. Listen to the recording. I'm going to have it up. I'm actually leaving town today, but I'm going to put up the recording before I go. Otherwise, it will get delayed to next week. So in about next 3 hours or so, 2 to 3 hours, you'll have the answer up. Short answer is this. Do not file a lawsuit unless you are absolutely desperate and you want the case to be decided one way or the other. Okay? So sit tight. You'll have my answer in the next couple of hours. If something is not clear, we can talk in a couple of weeks again. Okay?
Okay, thank you very much.
You're welcome, and good to hear from you. Take care.
Good to hear from you. Bye-bye.
Bye. See, some people, I recognize their names from many, many years ago. I think she and I have had an attorney-client relationship as well as, conversations over many, many years. Good to hear from you. Always a very pleasant surprise. Okay, so getting back to the next question. Daughter is, oh yeah, these are also some difficult questions. Sir, what I want you to do is, I know you're concerned about your daughter's extension. First of all, remember the OPT extension could go to 24 months because we have a regulation pending. November 11th, I think, is the last date of comments. So for all we know, she could have another few months to add on to that time. Number two, I want you to research before I answer these questions because I think you need some basic research done. You can go to our website and read the frequently asked questions on cap-gap extension. Cap-gap extension. Okay, read up on that. It will give you a lot of information, and I think a good source of information is Immigrations and Custom Enforcement, ICE website, because ICE basically oversees the SEVIS program through SEVIP. So go to ICE website. They have frequently asked questions on travel, on cap-gap extension. Once you've done all that, then contact me again. In 2 weeks, we'll talk about it. Okay? So cap-gap extension will protect her. Travel is restricted, and she may also soon have the option of getting another few months on her OPT STEM extension. It's going from 17 to 24 months. Okay, I am going to go into, let's see, we still have a few questions left. Let me just have some water. Okay, arrow 1, 2, 3. Current H-1B is expiring December 2015, 6 months, 6 years max out. Guys, I'm losing my voice. I hope I have some, I guess not, looking for some halls or something. Okay, so current H-1B is expiring in December, maxing out, I-140 approved, not current employer. So H1, H4 extension is pending in regular processing. Can I transfer my H-1B to another employer after December 2015? Or do I have to wait until my H-1 extension? Look, here is the problem. Once your I-140 is approved, you can get 3-year extension through any employer as long as the I-140 is not revoked before your H-1 approval. But as a practical matter, you should start your H-1 with a new employer right away, no problem, because you are still in status till December 2015. So you can have an employer file an H-1, but don't join them until the H-1 is actually approved. That way you are much more secure. So do it premium processing. If the I-140 is withdrawn, I already answered this question in great detail that if it is withdrawn, your priority date goes away even if it is not fraud. My wife and my I-94 expiring in December 2015. Will we get automatically extended? Yeah, you should be able to get up until December 2018 because your I-140 is approved, whether you do it through the new employer or through this employer. Okay. Any questions on this? Star 5. Star 5. Any questions on this? Okay. Let's go on to the next one. I'm a green card holder. My minor son, 7 years old, has a tourist visa. Is it a problem because I've got a green card? And the answer is, obviously, I'm assuming when he got his tourist visa, the fact that his father or is it mother is a US green card holder was made clear to the consulate. If indeed that was made clear, this is not an issue. Okay. So if it was not made clear, we should talk about it a little bit more. I hope you're on the phone. Press star 5. If you're on the phone, press star 5. Yes, you are. Okay, excellent. Go ahead, please. Go ahead.
Yes, hello. I'm sorry, I couldn't hear so much. I was the one asking the question.
No problem. I'll repeat it. I said, when did the child get their tourist visa? Do you know?
It was given to them, I think it was about 2009, like 5 years ago.
5 years ago. Okay. And were you then a green card holder or not?
I was, but this tourist visa was never used. The issue
No.
was that
Hang on.
the father
That's not my question. I'm trying to establish something, so bear with me for a moment. So when the tourist visa was applied for, you were already a green card holder, right?
Yes.
Okay. So when you apply for a tourist visa, in the application there is a question about your family in USA. Was the government or the consulate told that you had a green card?
I didn't say that I had a green card in the application.
Yeah, well, that's a big problem because that is fraud. And when you have a fraud situation, government can take the position that this is a permanent bar from entering the USA. Even I would take the argument this is a child and it's not his fault that there was a misrepresentation on his file. But this is a much more serious problem than mere entry into the USA. So this needs to be looked at a lot more carefully than I can in this call. I would strongly recommend if you have a lawyer, go talk with them, have them review the case. My concern is permanent bar from entering USA because of fraud. Okay?
Now, just in general, I mean, if nobody just looked at the case thoroughly and just by viewing, see a person with a green card and a child with a tourist visa, just at the point of entry, regardless of any application or anybody looking into it thoroughly. I understand if they do, it might be a problem, but just in general, a person comes in with a green card and their child have a tourist visa. Could it cause an alert? Or
well, yeah. Here's my problem. Remember, the law says anybody can be permanently barred from entering the USA if they commit a misrepresentation for acquiring a visa or attempting to acquire a visa or immigration benefit. So when you bring your child in, knowing that this entry is wrong, you can be subject to the same bar. And remember, just like I asked you these questions, these are quite frequently the very first questions that will be asked by the Customs and Border Protection also. Now, yeah, if you don't get caught, that doesn't mean that you haven't done anything wrong. My advice to you, ma'am, is do not take any action without checking with your lawyers. Have a detailed consultation, understand the consequences of what you are doing. See if there's a way to manage the fallout from this one error that you have made. Okay? I'm sorry, I have to go on to my next
All right,
call.
thank you.
You're welcome.
Thank you.
You're welcome. Okay. Folks, some situations are too complicated to be covered with a quick answer, and that's just the way it is. Next question is from seeking approval whose PERM was selected randomly because ads were missing, the PERM was denied, there's an MTR. See, normally if there's merely a documentary mistake of this kind and we can prove that those ads were actually submitted, chances of getting approval are pretty good. As far as turnaround is concerned, only your lawyers can find out, let them call or let them send an email. I don't know if these times are published anymore. We do publish on our website some of the times. We do publish, for example, appeal times for Board of Alien Labor Certification Appeals. So, I don't know what the turnaround time is. Typically, government wants to wrap everything up in 6 months, but that's not something I can guarantee. If it's an appeal, it could be 3.5 years, but if it's a motion to reopen, reconsider, it could be just a few months. There's good probability of success if they can prove that this was just a error on part of the Department of Labor and that they had submitted the documentation. Okay. *5 if you have a question. All right. Let's go to you. California, go ahead, please. California. California, go ahead. Sir.
Yeah, hi. So I have seen the ads myself, and those ads are present. The attorney is saying that those ads are already submitted. Could it be a problem from the CEO while reviewing? I would not say a problem, but they might have missed it from the side.
Well, look, it's so difficult to track some of these things down, but do remember that as long as the lawyers can prove that they had submitted the ads. Okay. One example is, we had a case like this a few years ago. Government said we hadn't submitted a document. I said, wait a minute, pull out the scan that we did before we sent the document. It took us 3 minutes to find out that in the scan those documents were there. So we submitted a copy of that scan to the government and said, look, here is a copy from our file showing the complete package that was sent to you. You misplaced these documents, not our fault. The case was approved quite quickly. Okay. So if they can prove that they sent these documents out to the government, chances are pretty good.
I see. Okay.
Okay.
So we have sent those documents. We have sent those documents again. And marked that particular section where the ads were published for that particular day. Now, what I wanted to ask was, do we receive any sort of reply from the Department of Labor saying that?
No, there are no receipts. There's only a final decision usually.
Okay.
Okay. Good luck to you.
Okay. Sure.
Sorry, you were saying something? I cut you off.
Yeah, very quickly, one last question. So there are two categories here. One is consideration to the the review to application, and then there is another category where is a government error. So I've seen the government error timelines are pretty, current.
Yeah, they are very
so
fast.
Would it be a classical?
Yeah, this could be a government error. You can claim it. Government error queues are usually a matter of days as opposed to months.
I see. Okay.
Good luck.
Thank you very much.
You're welcome. Okay, I have one more hand up. If it's a new question, I won't answer it now. So if it's a new question, please put your hand down, press *5 again. Okay, Georgia, go ahead. Georgia?
No, it's a new question.
No new question. Wait, please. Let's just wait. I will make time before I go. So put your hand down, press *5 again, and your hand will go down. Okay, this is California. You have another question? California?
Rajiv, this is again severity.
Which question number, sir?
Hello?
What question number?
The question on I-140 validity, the question number 3, severity.
Okay.
Yeah. So, question on again I-140 validity. Does the I-140 become invalid if no successor in interest, or there is no new 140 filed when the company has been acquired? Does it become invalid if nothing has been done? Of course, it is not been.
I'm sorry, I don't understand. What is your question?
The question is on the validity of I-140. The 140
Okay.
is not revoked.
All right.
There is no.
All right. Hang on. All these issues should be addressed to the lawyers who know what the transaction is. If it is you said the FEIN is the same. If the FEIN is the same, chances are your I-140 is okay. But if it's not a successor in interest or the same company, it's been extinguished, you will lose your priority date. Okay?
All right, thank you.
Good luck. Okay, folks, if it's a new question, please don't raise your hand. Put it down if it's a new question. Press *5 again and put it down. I'm not sure what everybody's doing. I have more raised hands. No new questions. Let me finish what I'm doing first. Okay, I covered that. Okay, where was I? Lost here for a second. We have a question about citizenship taking too long, and you got different replies. I would go with the reply given by the congressman's office. Congressmen usually have deeper access to data than any other source. Okay, so if you want to do a follow-up, do a follow-up with congressman's office. Okay. I'm not going to ask for a *5. I'll do *5 at the end of it. I'm just going to put everybody's hand down and ask for new questions. Just give me a minute. Let me finish all my questions. Okay, I think we are done here. All right, folks. First of all, okay, nobody raise your hands. Only if you have posted a question. If your question has been posted and you have a follow-up on that, press *5. No new questions right now. *5 for follow-ups, please. Then we'll do new questions. *5 if you have a follow-up. Okay, there is one. Pennsylvania, go ahead, please. Pennsylvania.
Hi, yesterday I posted one request asking actually my I-140 was, my I-140 was showing as pending in online from 2009 onwards, and when I checked with my employer, it was saying like it was approved, and after that I was working with a new employer now, and my I-140 is approved. After I got my I-140 approval, I started putting the old priority date as per my lawyer saying like it is approved. So in this case, the new lawyer who posted this request, he told like it is, he raised it as a typological error. So just want to check, is this the process followed for putting the already approved I-140 cases?
Okay, I'm sorry, I didn't quite understand what you just said. What question number are you?
I don't.
You said you
This
posted.
is regarding the Texas request service center request where I raised regarding posting of my issue in the email. I sent you an email as well day before yesterday regarding this.
Okay, you sent me. That means you haven't posted your question. You asked it in the email. Sit tight. I'll get to you. I don't know what you're asking. No, wait. Unless it's been posted on the forums, it's a new question. So sit tight. Give me 1 second.
Yes, I posted on the forum yesterday. I even posted on the forum.
So that's what I'm asking you. What question number are you? I don't know what question number are you. What is your login ID?
My login ID is Sriharsha AD.
Sri what?
SRIHARSHA AD. Sriharsha AD.
I don't think there's any such name today.
Oh.
Not sure. If you can tell me the question number, I'll be happy to take your question now. Otherwise, wait for your turn, please. Okay? I'm going to put you on hold.
Oh.
New Hampshire, do you have a posted question, sir or ma'am? New Hampshire?
Hello?
Yes.
Yeah. Hi, sir. This is Avinash.
Yes, sir. What question number are you?
Actually, I don't have a question. But,
why? See, I'm speaking simple English, you guys. I'm speaking simple English. I'm asking you if you have a posted question, raise your hand. Otherwise, keep it down. I don't know what's wrong here. We gotta proceed in an orderly manner. Bear with me. I'm gonna come to your questions, but first I have to answer the posted questions. Okay, I'm assuming all the posted questions are done because both hands that were raised were not posted questions. Now, any question, new, old, I don't care, whatever, press *5. Press *5. 1, 2. All right, 2 people only. 3. Folks, raise your hand if you have a question, and then we are done. I will not answer any questions past 3 because I am a little pressed for time today, and I was trying to make sure that I answered everybody's questions. So don't take your time about it. If you have a question, raise your hand now. Otherwise, we are done. 3 questions, 3 people only have hands up. 4 hands up. Okay, I'm calling it done at 4. I won't answer any more questions. If you have not raised your hand by now, we're done here, okay? So let's start in the order people logged in. So let's go to Pennsylvania first. Pennsylvania, go ahead, sir or ma'am.
Hi Rajiv, I'm working for company A for like a in-house project, like 40 hours per week. I'm on H1. So is it possible for me to work for more than 40 hours, like getting into another project with another employer?
Yes,
or
sir.
With the same employer?
Yes, no.
Some other new projects, and can I work
Yes.
more than like 40 hours? Is that possible?
Well, there are 2 questions here. One is, can I work more than 40 hours? The answer is yes. If you have that capacity, and you can prove it to be a genuine capacity, there's no problem. Can you work with the same employer more than 40 hours on another project? You probably will have to do an amendment to include the new project. But can you do it with a new employer? Yes, you can do a concurrent H1 with a new employer. I had a very interesting case a couple of years ago where one person was working 3 full-time jobs on 3 concurrent H1s. Okay, so one question that comes to mind is, how is that possible? You can't work 120 hours in 1 week. And the answer is, this guy was a database administrator. He was only on call for 3 companies. So he only went in for troubleshooting, and he was getting paid 3 full-time salaries. Perfectly legal. Okay?
Okay, sounds good. Thank you very much.
You're welcome. Good luck. Okay, 3 more raised hands in the order people logged in. New Hampshire, go ahead, please. New Hampshire, go ahead.
Yeah. Good afternoon, sir. This is Avinash. Actually, I'm done with my master's in New Hampshire. I applied for OPT. I got RFE for my OPT. Regarding actually, whenever first time I came to US, I transferred from Western Michigan University to Prairie University in New Hampshire. I didn't do any courses in Western Michigan University. That's why RFE states that I have to submit 20 required documents to USCIS for approval of my OPT. I'm very scared about that, sir. Can you please tell me the solution, what I have to do now?
When is your RFE deadline?
Actually, I got an RFE on October 6th. My RFE deadline, I have to submit on or before January 2nd, 2016, sir.
Okay. We are dealing with a case exactly like yours. Okay. So do me a favor, send me an email I will send you some of the law that applies to this situation. Basically, what I have told, and you can do the same thing if you want. What I have told our client is this: go to the DSO of the school where you are transferred and tell them to give you a letter saying.
Yeah, I got a DSO, sir.
I'm sorry?
I got a DSO letter from my school, sir.
As long as the DSO says they have looked at your background and that the transfer was done completely in according with the regulations, I think you'll be okay.
Yeah, okay, sir. Sir, I can't able to understand. Can you please say that again?
Yeah, just get that done. And if you want to double check with me, call back again in 2 weeks. By that time, you would have all the research and everything done. I'll be able to give you a more complete answer.
Okay. Can I email you this?
Don't email me. Like I said, I'm traveling, so just I'll be here next Thursday in the next community conference call. Let's talk again, okay? Just post your question on the forums. I'll be sure to get to it.
Sir, but actually it's been 1 month, sir. I didn't find any solution for my RFE. This is very important.
Well, I don't have time. I'm sorry. I don't have time to do this research. Somebody else is working on it, and they will do it when they will do it. My office is taking care of it. I can't do anything for you. Okay.
Please tell me one solution, sir. What I have to do.
I just told you, log back into the conference in 2 weeks. What is the problem? You have up until January. Yeah, log back into it. I'll have to look at the regulations. I just don't have time. I have so many things going on at the same time. So, I don't want to tell you something I'm going to do it and then not be able to do it. I've tried that. My calendar is very busy right now. So talk to me in 2 weeks. If you are in more hurry than that, just get yourself a good lawyer. Let them do it for you. Okay? Guys, don't raise your hands, please. I'm not going to answer any new questions. All of a sudden, there's 4 more people. This never ends. Please stop. I asked you in the very beginning, raise your hands. Don't do that, please. If you're new, I'm not going to answer any more questions. Done for the day. Texas, go ahead, please. Texas.
Hi. I have 3 questions regarding maintaining my status and staying in the US.
Okay.
I'm currently on my OPT extension. And it expires in May next year.
Okay.
And I'm planning to go to India this December. Would I be having any problems when I come back?
Hang on. Take a step back. Are you currently employed? Do you have a job in your own field?
Yes.
Okay. Normally.
Yes, I'm currently working full time for a company.
You're currently working what? I'm sorry.
For a full-time company.
Okay, good. So you are working full-time, you have a job in your own field. Do you have a visa stamp on your passport, F1 visa stamp?
Yes.
Okay. And you have not been out of work for any number of days, have you?
Yeah, I've been working for about 2 years now.
No. On the OPT, have you been out of work at all?
No.
Okay, you said you've been working for about 2 years. Was it on a STEM extension or did you have a CPT?
No, it was OPT and then STEM extension.
Oh, good. I don't think you're going to have any problem traveling as long as you are, what about the H1 application? Are you filing an H1 in April?
They filed it this year. It didn't get picked up. They're going to file it again next year.
Are you going to travel and come back before April?
Yes, I'm going to come back January 1st.
I don't see any problem. Just make sure you get your I-20 endorsed for travel, okay?
Okay.
Go for it. I don't see any problem.
And okay. And I'm planning to apply for another I-20 to extend my I-20 status, just in case my H1 doesn't get picked up next year. Is that going to be extending the current service number I have, or is that going to be a new one?
Well, I think we might have the 24-month rule passed, So you might be able to get a few more months on your I-20. I don't know what the logistics are going to be, but it should be basically a similar process to the STEM extension. Okay?
Do you know when that might go?
I do not know that, but it's got to be before February, that's for sure. Okay? Good luck.
Okay.
Sorry, did you have another question?
Hello, I have another question.
Go ahead.
Hello?
Go ahead, ma'am. I'm listening.
Just in case I have to extend my I-20, do I still have to go and get my visa stamped for F1 again?
No, ma'am.
Do I do that here?
Not normally. Not normally. No, ma'am. Only if you want to travel. Visa stamping is not a prerequisite to I-20.
Okay.
All right.
Okay.
Good luck.
Thank you.
You're welcome. Okay. Last question, guys. Back to California. California, go ahead, please. California.
Hello. Yes.
Yes, ma'am.
Hello.
Yes, ma'am.
Yeah. So my question is that we have filed for a naturalization application.
Yes, ma'am.
And thing is, it is beyond the time. And now when we are, we took the application back because we went through a boot camp and applied for a citizenship. We are finding some issues in it. Like some of the points which need to be fixed, they have not done it. So is it like we can amend this, like we can correct this information with the USCIS?
Did you file online or did you do it through mail?
It is like there was a boot camp here from the
Okay, so I have no idea. I have no idea. It looks like a local program, pilot program. I have no idea how that would work.
Yes.
Let me tell you the simplest way to handle this. Just go to your congressman's office, tell them to help you find out what to do about this. I think you should be able to fix it.
Yeah, he went to the congressman. He said that your application is in a security check, like with the NBC center. So we have to wait right now. And there is no limit of time how much long it can take.
Let me tell you something. This is the only thing that concerns me about your questions. As long as there is no misrepresentation, as long as it is just errors, those errors can be corrected and you should get a request for evidence probably in a case like this. But if there's a misrepresentation, you need to get yourself a lawyer right away. Make sure it gets taken care of right away. Okay?
Okay.
Good luck.
Okay.
Yep. Okay, bye-bye. Folks, as always, I am delighted to be of service and be able to help you folks out. I'm sorry, I can't take any more new questions. We're done. I have to leave. But I'll see you again in 2 weeks, okay? Thank you all. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.